Okay, thank you for your patience, everybody. And welcome back. We now reconvene into public session. This comes to the stage where I will announce the decision that's been reached by the subcommittee. Bear with me while I change glasses, my reading glasses. Don't get old, it's not a fun journey. Okay, now, please do sit comfortably. It's always a bad thing to give a politician access to a microphone, but this is going to be a formalised speech. I've got a fair bit to read out, so kind of chill if you can. Right, Portsmouth City Council, Licensing Subcommittee, application for review, Monty's Restaurant and Bar, 69 Castle Road, Southsea. Review hearing Thursday the 24th of August 2023. All parties shall receive written confirmation of the decision and reasons. Decision. The subcommittee has considered very carefully the application for review of a premises licence at Monty's Restaurant. It gave due regard to the Licensing Act 2003, the licensing objectives, statutory guidance and the adopted statement of licensing policy. The subcommittee considered the relevant representations, both written and given orally at the hearing by all parties, and human rights legislation and the public sector equality duty has been borne in mind while making this decision. The subcommittee determined that it was appropriate, given all the circumstances, to impose a set of conditions circulated and agreed between the parties in advance of the hearing, save for one resident who emailed during the course of the hearing. Reasons. It was noted that whilst brought by a single resident, the application was supported by 30 others and seeking the imposition of conditions. Matters of concern are relating to the licensing objectives of crime and disorder and public nuisance. Planning restrictions currently in force restricting noise at the premises, the nature of the locality being heavily residential, and the findings/outcomes of a previous historic review were raised. Since the current review proceedings were brought, an assault of a resident by patrons of the venue has taken place. In light of this, the stance of the applicant changed from requesting the imposition of conditions to revocation of the licence. However, at the hearing it was confirmed that conditions circulated in advance had ultimately been agreed between the applicant and the premises licence holder. The application for review attracted representations from Environmental Health, a regulatory service, and the licensing manager. It is noted that enforcement action by Environmental Health, following the witnessing of a statutory noise nuisance at the premises, included the service of a noise abatement notice under the Environmental Protection Act 1990. It is stressed by Environmental Health that the premises is not suitable for live music or amplified/recorded music, given it is within a row of residential properties, and conditions are recommended effectively removing the usual Live Music Act 2012 exemption so as to expressly prohibit regulated entertainment consisting of live or recorded music at the premises. At the hearing, it was confirmed that the 8 conditions agreed by the parties were endorsed by Environmental Health and considered sufficient to address their concerns. The Licensing Department report a number of issues of concern and indicate that a formal written warning has been issued. Likewise, their position was clear that the agreed conditions would address the licensing objectives. The applicant's representative addressed the subcommittee and outlined the context in which the conditions have been agreed, referencing specific points of the residents' representations, noting the change in the style of operation of the premises as well as the locality, given the changed status of the street. Environmental health officers had also witnessed nuisance and taken formal action, adding credence to residents' concerns. For the premises licence holder, the subcommittee heard that the applicant had not prepared to fully address issues raised by residents due to an agreement of the conditions, and both parties stressed that certain issues, particularly facts surrounding the assault, were contentious, with neither side making admissions. The subcommittee is clear that it is not investigating or determining criminal offences and accepted advice that the lack of police representation ought to be given weight as the lead authority for matters of crime and disorder. However, the licensing objective could still be considered when raised by residents or other parties. It was also stressed that the weight of evidence before the subcommittee supported the endorsement of the proposed conditions. Given the responsible authorities and all but one resident at that time, an email was received during the course of the hearing from the remaining resident indicating a reluctant acceptance of conditions. I hope you're still bearing with me. The subcommittee determined that it was appropriate to impose conditions as agreed and not take any further or lesser action, and accepted that the overwhelming weight of evidence before it supported this as a reasonable and proportionate approach. When imposing the new conditions, wording should be included to make clear that Section 177A of the Act does not apply and that conditions have been added on review of the licence. For the benefit of residents or others viewing today's hearing, the conditions agreed to relate to CCTV, training, Challenge 25, refusals register, no drinking outside, neither live nor recorded music is permitted, the removal of late night refreshment, the amendment of hours, and the requirement of a personal licence holder to be present during any bottomless brunch promotion. There is a statutory right of appeal which must be lodged at the Magistrates' Court within 21 days of receipt of the formal notification of the decision. Formal notification of the decision shall be set out and will set out that right in full. And that, you'll be pleased to know, is the end of that I had to read. So thank you for coming along. That's the decision. If anybody does wish to appeal, which seems unlikely, then you'll be given advice how to do so. But hopefully that's an agreement for all parties.
Could I just clarify one point, sir?
Yeah.
In relation to the conditions 1 to 8, those conditions have been accepted in full, even though you've just read out a summary. That doesn't quite match, but in essence you are making decision 1 to 8 as agreed are implemented.
Yes, as obviously for the submission of those conditions that we received and we have in paper, yes, I can confirm that's as it stands. Mr. Walgrove, anything? Are you okay? Splendido. Okay. Thank you. May all escape. Thank you very much indeed. Ta.